Morning, everyone. We're going to go ahead and get started. Welcome to the ComMACL Carries Cal OSHA webinar series. If you are, we launched it last month with our workplace violence prevention webinar where we went over compliance tips for SB 553. If you missed that, feel free to jump on our website and make sure that you get it. My name is Rachel Kahn. I am the chair of the California practice, and I'm joined today by my colleagues, Megan Shaked, who is a partner in Cal OSHA lead, and Sam Rose, who is an associate in our Cal OSHA practice group and is located in Southern California. And this presentation today is on the Cal OSHA legislative, regulatory, and enforcement update. So what to expect as we go into 2024, what are the trends, what is the legislation, the regulatory updates that are coming through. So we are going to cover all of that. And to the extent that we aren't able to answer any questions today, please feel free to reach out to any of us at any time. Our contact information is in the slides that everyone is going to have access to. So again, my name is Rachel and I am the chair. Megan Shaked, who is a partner in both our workplace safety and employment practice, as well as Sam Rose, who is in both of our practice groups as well. And with that, I'll kick it over to Megan to start our agenda and to start off on our latest Cal OSHA updates.
Thanks, Rachel. Thanks for joining, everyone. We will be covering quite a bit today. So like Rachel said, we're going to dive right in pretty quickly, but just to give you an overview, we will cover our Cal OSHA regulatory updates. So these are the kind of rulemakings and regulatory updates coming through directly from Cal OSHA. Then we'll go over some important case law board decisions coming out of kind of the history following from ALJ decisions and some of them working their way through California courts. Then we will go through our workplace safety legislative update. It was a very busy year in the California legislature with respect to OSHA. So we have quite a bit of updates on that front. And then we wanted to kind of give a sense as we try to do every year on kind of the Cal OSHA trends and developments, what we see as enforcement priorities, where the agency is putting their resources and kind of what their goals are for the coming months and year. We did also want to highlight a few updates at the Fed OSHA level, since Cal OSHA has to be at least as effective as the federal OSHA program. Sometimes changes that happen at the federal level trickle down to California if they're not already in the works. So we wanted to flag a few developments on that front for you. And then we will round out with our predictions for 2024, and we'll see this time next year how we did. So starting off with our Cal OSHA regulatory updates, there's a whole slew of rulemaking activities that the division is working on at any given time. You know, they're working on dozens of rulemakings at any given time, but there are some that are the most active and the most likely to impact the clients that we work with day in and day out. And one of them is Cal OSHA's indoor heat illness rule. So for those of you who are currently impacted by having outdoor workplaces, there's an existing standard under Title 8, Section 3395 that applies to outdoor places of employment. And indoor heat doesn't currently have a specific regulation, although the hazard of indoor heat is addressed through the existing California Injury and Illness Prevention Program. So if a workplace currently has a hazard of an indoor workplace, the division, Cal OSHA, will kind of address it by scrutinizing your IIPP program, seeing if the hazard has been properly identified and addressed. But going forward, anticipated next year, there will be a specific indoor heat illness prevention standard. And currently this is in the rulemaking phase. So there've been a couple of draft versions of the rule, and the most recent version had a 15-day comment period that closed at the end of November. And we expect that this is going to be the version of the rule that goes to the standards board for a vote. That will be a new notice period when the final draft is presented to the board for a vote, which we anticipate is going to take place at the March 2024 meeting. They'll issue the final draft, say this is the version that's going for a vote. There's one more opportunity to make comments to the standards board meeting before they take their vote. And we anticipate the timing of this because, as every year, Cal OSHA focuses on heat illness during the high heat months. And there's an attempt, as you can imagine, to make sure that the indoor heat rule is in effect for at least part of the high heat months next year. So the proposed heat illness standard, as it looks right now, has, in contrast to the outdoor heat illness rule, which applies to all outdoor places of work, the indoor heat illness rule has kind of a trigger system where if you have a certain threshold temperature that's met, then there are certain requirements with a higher threshold temperature triggering additional requirements. You'll see here that there are a few exceptions to the indoor heat illness rule. And some of them may not come as a surprise: remote workers, shaded areas that are used exclusively as the shaded areas that are required under the outdoor heat illness rule don't fall into the requirements. There's also the most recent update kind of changed the exception for incidental heat exposure, where if an employee is exposed to temperature kind of in between 82 degrees and 87 degrees for a short period of time, then the requirements may not be triggered. How practical that exception is for many workplaces is kind of questionable, but that's what the division was willing to do for that exception. They didn't want there to be a blanket exception for incidental heat exposure. And then there's an exception for emergency operations, as well as vehicles. There's a partial exception for vehicles with effective and functioning air conditioning, where one of the requirements for the indoor heat illness standard is kind of a engineering controls. And one of the things that you have to do is you have to take measurements in order to assess the temperature and then take additional steps depending on what the temperature is. So for vehicles, you don't have to take the measurements, but you still have to comply with the other requirements. So again, interesting take on the exceptions within the rule. And then taking kind of a step back and just giving you a broad overview of what the draft proposed indoor heat illness standard would look like. It has some similar aspects to the outdoor heat illness rule. So there's a written prevention program requirement. There's a training requirement. There is a requirement to provide access to cool down areas. Just like with outdoor heat, there's additional rest periods that need to be provided, as well as acclimatization obligations. So these are all, even if they're not identical, they're the same types of requirements that we see in outdoor. Some of the details are different, and employers will need to take care to make sure they're kind of thinking through how this would apply for their workplace. Another big regulation that the division is working on currently is an emergency temporary standard with respect to silica. And this is intended to be limited to use of artificial stone. There has been quite a bit of kind of testimony and information presented to the standards board and the division about increased rates of silicosis amongst workers who cut, polish, work with engineered stone, so kitchen tops, countertops, and they're seeing much greater rates amongst engineered stone as opposed to natural stone. Silica is present in natural stone. It's been a known hazard for thousands and thousands of years, but given the increased rates they're seeing amongst artificial stone, there was a huge push to get this pushed through as an emergency temporary standard. So the ETS went through a similar process as the COVID ETS, and it's going to a vote with the standards board meeting this December. So we realize this, doesn't apply to everyone, but if anyone is impacted by this and has additional questions, we're happy to answer those. OSHA is also going through some revisions to the lead standards, both in general industry and construction. Here, there has been a push by those who are impacted by lead, those in the kind of California health workers who are familiar with this area, a push to update the standard to kind of bring it up to speed with current understanding of lead toxicity. What are the levels that are appropriate? What are the levels that should continue to be in the standard going forward? So this has also been working through rulemaking. There have been quite a few drafts. These regulations are quite detailed and involved, but the big takeaway is that there is a very significant lowering of the threshold of what is allowable exposure. And practically speaking, what this means is that there are many employers who may not have been swept into the existing lead regulations because those exposure levels were at a certain level, they were higher than would have impacted them. But this is a change that will likely sweep a lot more employers into the requirement and will call for compliance by a much bigger group of employers who might otherwise not have the lead exposure regulations on their radar. So this is one to definitely keep an eye on. The division has hinted at this going to the standards board for a vote in February 2023. And the second 15-day notice period closed at the end of October. So there was, again, a big push to kind of get this. This has been in rulemaking for quite some time, but there's a push to get this over the finish line in next calendar year. I'll pass over to Rachel, who's going to finish up our regulatory update on a couple more topics.
Thank you, Megan. So for those of you on the call that are subject to the aerosol transmissible disease standard, I know that that's going to be a very small select group of you. However, I'll go through kind of where the revisions are here in a moment, but even if you're not subject to it, it is worth paying attention to because it really signals to us how OSHA is looking at communicable diseases overall. And as they start to push through the rulemaking process, the general infectious disease standard, I expect them to take a look at the aerosol transmissible disease standard kind of as a template for that. So, again, even if you're not subject to it, it's one that, all employers should pay attention to. So the aerosol transmissible disease standard was kind of somewhat of a sleepy standard, for many years that didn't really get a lot of enforcement because it was kind of a small subset of diseases that were implicated. But of course, during COVID, it became front and center, for particularly our healthcare clients and skilled nursing facilities. And we saw a lot of activity and a lot of enforcement. And it's a massive standard. It's very complicated. And despite what the Standards Board may say, really is not workable in an outbreak or pandemic situation. So, after COVID, I think that, or during COVID, and for those of us that worked intimately with this standard, and I think OSHA as well, saw that there was a lot of areas where there could be revisions to the standard. And we did have one advisory committee meeting on that about maybe 2 years ago, a year and a half ago at this point. We have not seen a new draft come out from that. What we know will likely be in a new draft when it does come out is that COVID-19 will be added to Appendix A. So, for example, for those of you who are not familiar with it, Appendix A includes all of the diseases that are subject to the aerosol transmissible disease standard and whether they're considered requiring airborne precautions or droplet precautions. And there's also, it covers new or novel pathogens, and that always has to be covered and treated like it's an airborne disease. So because COVID-19 was a new pathogen, that's how it was treated. That's why it was subject to airborne precautions even early in the pandemic when we saw organizations like the CDC take a different approach. So that's really one important thing to note, that COVID-19 will come out of the novel designation and become its own pathogen listed there in its own right, and it's going to go under airborne infectious disease isolation procedures. So what else can we be thinking about when we expect those new revisions? For anybody who has dealt with them, you know that there's a lot of documentation around the transfer procedures, around exposure incidents. So we'll wait to see if we get any more movement from that. But for any of the employers on the call that are subject to the ATD standard, I highly recommend that you participate in the advisory committee meeting or come to us and have us participate on your behalf, because this is a really important standard. And this is the time to put in input. And I think that OSHA will be particularly interested in employers' input, because we've just saw so much enforcement around this standard during COVID. And speaking of COVID, the OSHA COVID-19 non-emergency rule still alive and well here in California, and it's going to be effective through 2025, except for the record keeping requirements that are going to continue for an additional 3 years. And I'm sure everyone on this call is intimately familiar with the standard, but just as a reminder, OSH does have a variety of different resources on its website. One of the things that we do want to flag for everybody is that there is an upcoming change in January of 2024, and that's the sunset provision of the part of the labor code that required employers to notify employees if there was COVID at a facility. So there was a change last year that allowed employers to post those notification requirements, but this year it is going to sunset at the beginning of 2024. However, the close contact notification that is in the actual regulation will continue. So those are two different types of notification requirements. So make sure that you understand that just because one is sunsetting does not mean the other one is. But it will at least provide a little bit of relief for employers who are continuing to have to post anytime that there is a COVID exposure in the workplace. And, the last update for the COVID-19 standard we saw in June of this year, and that was for changing the definition of outbreak. So it's now defined as 3+ COVID cases during a 7-day period, and that's down from the 14-day period. So that should make your outbreak analysis a little less in a shorter period, so you're not going to have as many people get caught up in that outbreak designation so of exposed group. So to the extent that you weren't aware of that, that is there, and there is that update. So when you are doing those exposed group analysis, you have that shorter window to deal with. And general industry infectious disease standard. So as you know, we have the non-emergency COVID-19 standard. It is going to sunset, as we just talked about, in 2025. And the idea is that it's going to be replaced by a general industry infectious disease standard. Now, as when I was talking about the ATD standard, we understand that there is a draft of the infectious disease standard that's in the works. None of us have seen it. It's possible, as I mentioned before, that it's going to look like the ATD standard in some way, shape, or form, because that is a more general standard that covers any aerosol transmissible disease. My hope is that it is not as cumbersome as the ATD standard, because that is quite a beast of a standard, and hopefully it will be streamlined to look a little bit more like COVID-19 and not the ATD, but it remains to be seen. So that is one, certainly for 2024, everyone on this call should be paying attention to, because like the COVID standard, it's likely going to apply to all of general industry, and it's going to cover most likely, we don't know what's going to cover yet, but it's most likely going to cover, any type of infectious disease. So, we're talking about tuberculosis, measles, things like that. And I know you may be thinking, well, that doesn't really come up in my workplace all that often. But, I've seen those things pop up in a lot of different industries, in a lot of different positions. And so it is one that you should be paying attention to, and I expect is going to be a pretty heavy lift for employers to comply with. And with that, I'm going to turn it over to my colleague, Sam Rose, to kick off significant cases and board decisions.
Thanks, Rachel. So we had a few interesting and significant cases from the appeals board this year, and actually cases that ended up coming out beyond the appeals board from the Court of Appeals. So we just want to update you all on that. Some of them have more of an impact on our work in the appeals, but it's good for employers to know kind of the landscape of how appeals are working and the way the board is looking at the way employers file their appeals. So the first case that came out was LNS framing. This case is less significant for the merits and more for the what it stands for in terms of amendments. Essentially what happened is that the ALJ, well, the division asked to amend the citation at hearing and then again in their post-hearing brief. And the ALJ denied those requests. The board basically said that the ALJ was wrong and that the amendments were proper and should have been granted. The employer then petitioned that decision to the Court of Appeals, and the Court of Appeals agreed and said that the division did have a right to amend their cases or their citations. What's interesting about this is there's kind of a split opinion on whether this case is significant. The division and some of the ALJs at the appeals board have said that this doesn't really change anything. They've always had the ability to amend their citations either during the appeal or in their post-hearing brief after all the evidence has been heard. We have a different perspective, which is that, they are allowed to amend their citations, but they have to, the employer has an opportunity to argue that they're prejudiced by those amendments. And we think that there's a possibility that this case will take away that prejudice argument and allow the division to just amend citations at their own discretion. We've already started to see some practical impacts of this case, which is that we filed a motion to amend a citation and cited LNS framing in our motion. the appeals board granted our motion, but did not put LNS framing in their decision. So we'll see how this case plays out practically, whether they rely on it or whether it's just something that's going to hang out there and not exactly change appeals that drastically. But just something to be aware of, a case that's out there. The next case is Rios Farming. This one has to do with clarifying the law on access to clean drinking water for employees. It basically held that the water has to be as close as practicable, which means that it has to be as close as reasonably can be accomplished. I understand that doesn't provide a lot of guidance, but basically what that means is the employer has an obligation to make sure that employees have access to drinking water. And the appeals board went a little bit further and said that the employer's obligation could include finding other reasonable options, which is providing jugs of water to employees or water bottles or just other creative ways of making sure that employees have access to drinking water. So if you're an employer that is impacted by this issue, just make sure that you're thinking about it from all perspectives. Sometimes it might take a creative solution, and we can certainly help work with you guys on figuring out those kind of solutions. The last case is Granite Construction. This one has to do with valley fever, and it's a little bit complicated and confusing. I'm going to try and distill it down as simple as possible, but on the merits, the case was about whether an employer had an obligation to abate the hazard of valley fever. And the appeals board, well, the ALJ found that there was no evidence of valley fever at the worksite, and so the citations against the employer were invalid. The appeals board came out with a very interesting, bizarre, convoluted opinion that basically said, despite the fact that there was no reliable evidence of valley fever on the worksite, the citations were proper. The employer appealed to the Court of Appeals, and the Court of Appeals basically reversed the appeals board and said that the citations were again improper. Where it gets interesting is that the case was originally not published, which means that attorneys, employers can't use that case in briefs or motions. And so it really didn't have any practical application for employers to take advantage of the decision. The employer asked that the case get published. That was granted, so the case was published. And then the division worked really hard and kind of touted its success in getting that case depublished, which if the division works very hard to get something depublished, you can kind of guess that they think it's not a great case for them. So right now the case is not published, but the another employer, not Granite Construction, is working on getting it republished so that employers can take advantage of it. And it's important from our perspective because, one, for employers who are impacted by valley fever, it kind of limits their obligation to abate a disease or a virus or a fungus that's not actually present on their work site. But for a broader application, it has a very interesting impact on the definition of exposure, which is that the division tried to take the position that if a fungus is present in the area, maybe not on the work site, but around the work site, then the employer has to work to abate the possibility of exposure to that fungus that's out in the world. And the Court of Appeals said that's kind of a broad definition, and we don't think that that's necessarily the proper definition. And so it kind of limited the liability for an employer to, when it comes to exposure to something that's not on their work site. So we're hoping that it gets published because it could have some benefits and it could be useful for employers down the line, but that's an ongoing fight. And you can check out our blog because we've been following this case pretty closely, and we'll provide updates on there as it makes its way through the courts. On that, I will turn it over to Megan to talk about cases that came out on late appeals.
Thanks, Sam. I'll talk about the appeals, the late appeals cases, but we did get a question, excuse me, about, excuse me, on Rios farming. So I just wanted to clarify. So Rios farming was a case under the outdoor heat illness regulation 3395, and the regulation as it stands requires water to be located as close as practicable to the areas where employees are working. And in this decision, the board clarified what as close as practicable means. And in this case, really for all purposes under 3395, they said that what that means, that phrase means that the water must be as close as reasonably can be accomplished to encourage frequent water consumption. And the facts in this case is that there were vineyard workers working through, long trellises of grapevines, and water was placed in certain rows, but not in every single row where workers were working. And there was testimony about workers having to climb through the trellis, or alternatively, they'd have to walk all the way to the end of their row and then into the row where the water was. And under those facts, there was a question about whether or not the water was as close as reasonably can be accomplished to encourage frequent water consumption, that folks might just forego drinking water because it's too difficult to get to the water. So that decision is important in that it clarifies what the expectation is for how close the water is to the workers and how easy the access is to the workers. So we just wanted to mention about late appeals. Hopefully everybody on this call is familiar with the really strict deadline to file an appeal after receipt of the citations. But we wanted to flag this because the board issued 4 decisions on late appeals in the last calendar year, and they really took every opportunity there was to remind employers about the strict nature of that appeal deadline, but also what's required of an employer when they don't file the appeal within 15 days of receipt. Because there's a procedure where if the appeal comes in and just on its face, it looks like it might not be timely, the board will allow employers to engage in a procedure where they can provide information to support their perceived late appeal. And that might be, we never received the appeal, or there might be something else. And the board clarified that certain things will not be considered as good cause for a late filing. And those things that were identified is, failure to understand the appeals process is not an excuse for getting the appeal in on time. Abating the citation is likewise not an excuse for late filing. They will not engage in the merits of the citation either. Some employers have argued, but we didn't violate the regulation. The citation, is without merit. They said that's a separate issue. You still have to appeal on time, or the board essentially loses jurisdiction to handle the matter at all. So just a reminder, a continued reminder about how important it is to meet the appeal deadline. And if there are circumstances where that deadline cannot be met, making sure that you're properly addressing that issue and getting the right information to the appeals board to make the decision about whether the late appeal can still be accepted and the appeal can still go forward. With that, Rachel will launch into our legislative update.
And I'll just to piggyback on both what Megan and Sam said about Rios. One of the things I think is also interesting about that case is that the employer is not the one that appealed that to the appeals board. The appeals board took that case up on its own motion. And so what I think we need to understand about that move is that heat illness continues to be a really important emphasis area for Cal OSHA, not only on the enforcement, side, the standards board side, but also the appeals board side. And we've seen a lot of case law in the past couple of years around heat illness. So I think it's just important to flag that again, how important heat illness is to the division and all of its units, and that we expect as we go into indoor heat to continue to see that trend. So if this isn't an area that you are paying a lot of attention to now, it's really one that you should be focusing on because it's where the division's focusing on. And then the last thing I'll say about granite construction is that this is also one to me that has, bigger implications outside of valley fever. It was important. It's an incredibly important case for valley fever because if we have any employers on the call that have to deal with valley fever, it's very difficult. There's only to abate. There's only certain ways of mitigating potential exposure to valley fever. But what I think the case is signals to us is the idea of how the division views employee exposure to potential communicable diseases. And I think that that's going to be important as we move into standards like the general industry infectious disease standard. I think how they viewed exposure here is going to shape how they view it there. And it's a very expansive view of exposure. So again, two things that I think signal how the division is thinking outside of these cases specifically. And as many of you know, we finished out the California legislative session earlier this year, and all of the laws had till October 14th to be signed by Governor Newsom. So we are done with the legislative session for this year until it picks up next year. And some of the statutes will be going into effect January 1, and then others on a rolling basis. And the largest one that we saw, or the biggest impact on the health and safety front, is SB 553, which was the Workplace Violence Prevention bill. And I'm not going to get into all of this. Is a huge bill. It has overarching implications, a lot of components to it. And I'm gonna, kind of get through this one pretty quickly, mostly because we've done a huge webinar on this one already dedicated to it. So if you want, the full details on SB 553, please go to our Cal OSHA webinar page or our blog and view the full webinar and read our blog posting, several blog postings on it. And of course, you can reach out to any of us if you want to talk about it in further detail. We also have a full service compliance solutions for employers to help employers comply with that. So we have a page on our website where you can see all the different things that we can help employers with as you try to comply with it. And we have a slide at the end of this as well. So with that said, I'm just gonna get through this because we for the sake of time. But SB 553 essentially did three different things. It amended the California Civil Procedure Code with regards to workplace violence restraining orders, and now a employee representative can get a restraining order on behalf of an employee. So that means a union can go and petition, not just the employer, a union can do that as well. It also amends the IIPP statute to include as an element of the IIPP that employers must have a compliant workplace violence prevention plan that is compliant with Labor Code section 6401.9. And that's kind of the big ticket item in the statute. And that adds that part of that section of the Labor Code that includes a whole litany of new obligations and requirements for employers on the workplace violence prevention front. And here's just kind of a brief outline of what that's going to entail. So now employers by July 1 of 2024 have to have an effective and compliant workplace violence prevention plan that can be part of your IIPP or a separate document. Our recommendation is to have that as a separate document. There's 12 elements to the plan. And in addition to the plan, you have to have a violent incident log. There has to be an annual training that includes interactive training, and there is several record-keeping components. And listed on this slide and the next slide are a summary of the 12 elements that are going to go into your written workplace violence prevention plan. And I'm not going to go through all of the elements right now, but one of the things that I want to flag for employers is that on their face, they look pretty simple, you know, maybe not a huge lift. But I will tell you, so this was originally based on the workplace violence prevention statute or standard that there is for healthcare. That's been in place since 2017. And as somebody who has worked on that, on compliance with healthcare employers on that for many years and litigated those, these are deceivingly complicated and detailed requirements. And so I really encourage all employers to start taking a look at this now and working through how you are going to comply. And one of the important things to know about this is that it has to be effective. And, you know, we all know that Cal OSHA loves that word. And what that means is that it's not just enough to have procedures on a paper. They actually have to work in operation. So it's not going to be enough that you know, put something in writing and you put it on the shelf. It's going to have to really be effective in practice. And that's where now is the time for you to get that information together, build out your plan, and it gives you time to see if it's going to be effective and work before that July 1, 2024 deadline. And the one thing I should mention is, you know, this is going to apply to all employers who are not subject to the healthcare standard with very, very limited exceptions. So we're talking about, you know, teleworking employees, and we're talking about if you have less than 10 employees and they're not in a public facing role, or the public doesn't have access to the area where they're working, and you are evaluating potential workplace violence hazards under the IIPP. So basically, this is applying to everyone. As part of the plan, you also have to have a workplace violence incident log. You are logging all of the different workplace violence potential incidents that could happen. Question that just came in, and this is a question that comes up very frequently. Will Cal OSHA have a template policy? And, you know, like we've seen with COVID, the answer is I don't anticipate that they will. You know, this isn't, while the statute is based on their draft regulation, this is a statute. This is not their regulation. They are tasked with enforcing it, but they are still rulemaking on a regulation that we're not going to see by the July 1, 2024 deadline. So, you know, I encourage employers to start working on this now, because, you know, we don't know what kind of guidance that we're going to see from Cal OSHA, if any, before July 2024. In addition, it also has workplace violence prevention training, and this is an annual requirement. And, you know, it goes through the different elements that the employer has to train employees on. But, you know, this is going to be a heavy training lift. And like I said, it has to be interactive, meaning that if you have on-demand training, you have to also have somebody that's going to be able to answer questions in a reasonable time, and that is knowledgeable about the plan. And Cal OSHA has not provided any guidance about how quickly that individual has to answer questions. So currently, it's a gray area. It could be immediately, it could be a day, we're not sure yet. So there's still a lot of things that are going to have to be worked out as we go through the compliance stage of this statute. And then this is just some additional information about the training. And there are several record keeping requirements. And this is, something that I really want employers to pay attention to as well, because this is one where OSHA loves to ding employers. It is low-hanging fruit. It is one that if you have a compliant plan, then they're going to look at your record keeping. So, don't, gloss over this as you're putting together your program. And just real quickly, AB 521, toilet facilities at construction sites requires OSHA before 2025 to submit to the Standards Board some rulemaking about toilet facilities and having at least one designated separate toilet for employees that self-identify as female or non-binary on job sites. Domestic workers, this is one that got vetoed. And, that's just important because, this could have had really huge implications. And it would have required basically any domestic worker would have been subject to all of the OSHA regulations. So as you can imagine, that would really open up a whole other industry that would be regulated. Vetoed, nothing to worry about at this point, but we see this one come up every couple years. And so, one to keep your eye on as in the new legislative sessions. And so what's next, as the legislative session is over, it's going to pick back up next year. And so we'll see what else the legislature has in mind. And the one trend that we have been seeing, particularly with workplace violence as a great example, is that the legislature sometimes gets tired of waiting for OSHA to finish its rulemaking process. And so we'll start to push things through. So, we'll see, what else the legislature deems a priority and whether or not they're going to be leapfrogging OSHA moving forward. And with that, I'll pass it back over to Sam.
Thanks, Rachel. So we always like to provide a little bit of an update on OSHA trends and developments at the agency. So we'll just briefly cover this. So these are the latest statistics on investigations and on-site inspections. The agency hasn't provided the newest statistics for the entire year, but we can kind of extrapolate these numbers over the course of the entire year and see they're a little lower than last year, but nothing significant. And so it seems like OSHA is continuing its enforcement obligations, and it's doing it to the greatest extent possible, which leads to our next slide, which is that the current extent possible is limited by the fact that the agency is severely understaffed. So if we look at the latest number they provided is that there's a 35% vacancy rate at the agency. And that's significant because if we look at their enforcement, while it's somewhat lower than last year, it's roughly the same. And so the people that the positions they do have staffed are working extremely hard to ensure that these citations are issued, that inspections are continuing, and that they are not pulling back on their enforcement capabilities. So we can expect that as these vacancies are filled, and they are definitely working to fill them, that the inspection rate will continue to rise, that the number of citations will continue to rise in 2024, and that the agency will continue to work towards getting back to full operation. In addition, they are working on establishing new locations, a regional office in Fresno, a district office in Santa Barbara and in Riverside, and then there will be a new high hazard unit that will be opening in Fresno. So that will be the third high hazard unit that the agency is opening. There is also the heat illness special emphasis program that has been in effect for a while now, and it continues to be in effect. That requires the agency to do a on-site inspection whenever there's an outdoor or indoor heat illness related complaint. It eliminates the possibility of the employer getting an investigation by letter. It requires a COSHA to go out and actually inspect the complaint. And if you look at the trends related to those complaints, you can see that this has become a hot button issue for the agency. We had 2 complaints in 2021, and the latest was through July of 2023. There was already 206, and each of those 206 complaints has to be inspected at some point. It looks like they had completed 74, and we don't know if that's because of a lack of staffing or because they just haven't gotten to the other 130 odd complaints yet. But the agency, moral of the story is that the agency is not taking any breaks, and they will be ramping up their inspection and their citation issuing into 2024 as they continue to staff the agency. So on that, I will turn it over to Megan to provide a brief update on OSHA.
Thanks, Sam. Okay, so if these are topics that are interesting to you, please take a closer look at the slides. We have quite a few slides on this as resource material, but I am going to go through these relatively quickly just to flag them. We often, see regulations or changes happening in California and having an influence over other parts of the country or federal OSHA. But in these cases, the question posed is, will these changes at the federal level, how will those trickle down to California if they haven't already, in order to maintain California's program as required, as at least as effective as the federal program. So the first is the Severe Violator Enforcement Program, which in California is enforced through the agency's Policy and Procedures Manual, which essentially is a resource for the division in conducting inspections and issuing citations. So the criteria to be included in the Severe Violator Enforcement Program at the federal level has changed in a way that essentially makes it easier to get swept into the program. So we'll see if there will be a similar change to California's program or not. On the subject of e-record keeping, there is an update to the e-record keeping rule. The proposed final rule was finalized back in July, and it will be effective January 1, 2024. And that will impact the next submission deadline, which is the beginning of March 2024. So for those workplaces that are noted in these under the third bullet point, those workplaces with e-record keeping obligations, this is something to pay attention to make sure that you're complying with the most recent update on that. There's references to Appendix B and Appendix A, so those are included in the slides for reference as well. Federal OSHA also has a new national emphasis program for warehouses. And we know that Cal OSHA was working on its own special emphasis program for warehouses. They currently have a special emphasis program on heat. So this would be a new special emphasis program at Cal OSHA. When federal OSHA announced their NEP for warehouse, Cal OSHA pulled back their special emphasis program because they have to make sure that they're aligned. So we know that this will be coming down the pipeline for California, and we know that the high hazard units are already doing high hazard inspections of warehouses, but this will be another kind of tool in the tool belt for the agency and outline specific requirements for those warehouse inspections. We've seen these on the federal level. And like I said, we expect to see equivalent changes at the California level as well. Just some additional detail on the national program if you're interested on what's entailed and what's supposed to be covered during the inspections and who is covered by the NEP. There's also a significant change rulemaking happening with respect to the worker walk-around rule, essentially who is permitted to participate in an inspection. And there is some draft changes to the regulation to expand who can participate in the inspections. And we have, our firm has a rulemaking coalition that's participating in this rulemaking effort. And we've submitted comments and there's an expanded comment period. We've requested additional time for people to be able to contribute to the conversation. And the big question is, what is this going to look like practically? In California, they're in a union workplace, their union representatives can participate in the inspection, but this would expand that. And so what is that going to look like? Does that mean that you have union representation in a non-union workplace? Does that mean that individual workers, attorneys, maybe on a, third-party litigation or, something that's not, maybe not directly related to workplace safety, but tangentially related to workplace safety? Are you going to have requests for plaintiffs' lawyers to be participating? And how does this impact kind of a whole other slew of groups of people who may have an interest in participating in an OSHA inspection? So we're keeping a really close eye on this to see what happens at the federal level and if there are any changes at the state level as well. And then just kind of wrapping up, we have quite a bit that the agency is trying to accomplish in 2024. So we just wanted to kind of give you some thoughts on where we think the continued efforts will be. We know that workplace violence is going to be huge in the next year. We know that heat illness will continue to be a key priority for the agency. This is something they are worried about every year as the temperatures rise and summers are hotter, and even periods of time that are outside of the period of time that's typically thought of as high heat. We have a heat wave in February, or we have a heat wave in late October. This is something that the agency is really, really putting a lot of focus on. I did note that there was a question about, how early might the indoor heat take effect? That would be, on the schedule that they're talking about now, it would likely be around July 1st, probably. Rachel, correct me if I'm wrong about that. But like you saw with those trends about indoor heat complaints, the agency is not waiting for that to analyze the hazard through the IAPP requirements. So have to think of it in terms of compliance under IAPP, but then as soon as that indoor heat illness regulation goes into effect, making sure that there's full compliance with that regulation. We expect high hazard unit will continue to be very active. And we also know the executive director of the board, Christina Shoup, has moved on to another organization, and they are working on a search for a new permanent executive director. Before she went out, she had highlighted that there's a major overhaul of the walking working surfaces regulation that's been in the works at the federal level for years. It was something that the agency at the California level had started taking on with some earnest to get through it in a reasonable manner through advisory committee meetings. We'll see if that kind of gets placed on the back burner during the executive director search, or if those continue in earnest the way that they were going before that staffing change.
And I would just, a couple things that I would just add to what Megan said. on the worker walk around rule, the Cal OSHA statute of who is allowed to participate is actually more narrow than the federal statute. So once we see revisions at the federal level, and Cal OSHA will have to adopt to be as effective, it could be a really significant shift we see in California, and California is particularly a place where we could see, as Megan mentioned, plaintiffs' attorneys, unions that have not been certified yet, those types of parties really taking advantage of it. So it's one that employers really should be paying attention to as it works its way through the federal level. And as Megan mentioned, indoor heat illness most likely is going to be effective in July. Along with workplace violence prevention. So what that means is that there's going to be a lot of compliance components and obligations coming effective July 2024. So this is a really good time to make sure that you're reviewing those things, that you are getting on top of those, because we all know that's going to become quickly. And any employers who are subject to the outdoor heat illness standard will know that Cal OSHA loves to come in and pick apart those written programs. And we expect workplace violence and indoor heat to be no different. And really an emphasis on reviewing those programs. So now this is a great time to get ahead of those. If there's any topics here today that you're particularly interested in, or any of these topics overall, we are going to be, following these extensively on our blog. So make sure if you haven't subscribed to our Cal OSHA blog, you do so you can get all of the updates as they come through. We have also all of our other blogs for the variety of different either Fed or on the LNE side. But we'll definitely be keeping an update on the Cal OSHA defense report of all of the things that we talked about today. For our webinar series, we're very excited that we are going to be, we're continuing to rolling that out on 2024. We're also going to be adding some topics here. So we'll probably be having one once a month. If there's topics that you are really interested in, ping us and let us know. And we're happy to include those or do some ad hoc presentations. So please feel free to reach out to us on that. And then the overarching Fed OSHA webinar series will be coming out soon as well. So if you have facilities outside of California, you should be receiving that information soon as well. And then one final plug for our workplace violence prevention. Well, we have our injury and illness record keeping masterclass, which is a fabulous program if you have if you're interested. And then our latest offering is our compliance solutions around workplace violence prevention. And as you can imagine, since this was signed in October, all of us have been working, with many employers on helping them to get into compliance. So we have a lot of different options and ways of assisting. So feel free to reach out to any of us and we can give you some more information about that. It's also on our website. And with that, I'm sorry, we're out of time, so we can't get through all of the rest of our questions. So if you have some questions that we weren't able to answer today, please feel free to reach out to any of us. Here's our contact information. We're happy to discuss any and everything that we went over today in more detail. And we appreciate your time and look forward to seeing you on our next webinar.